So dear students, in today's video, we will study about the basic concepts of customs law. So how custom law has been originated, historical background of it, and what are the things involved in the custom law. Those are all things we are going to study in this particular chapter of the basic concept of custom law. If we see the historical background of the custom law, the the word custom means a habitual practice or a course of action that repeats in like circumstances. The duty on import and export of goods have been levied from the traditional time by the all countries, and it has been described as shulka in Kautilya's Arthashastra, which consists of import duty and export duty to be collected at the city gates on both goods coming in and coming out. Right? This is not a recent kind of things. Since from the uh, like historical background also we can see it was called as shulka in Kautilya's Arthashastra, where any goods whichever are entering the city gate and which are going out of the city gate, these kind of tax were levied. It is clear that in ancient monarchy system of government, the traders bringing any kind of the goods, or the traders, they are bringing goods to a particular kingdom, had to take permission from the king to sell the goods in the kingdom. In order to take that permission, the trader had to offer certain gifts to the king over a period of time. This custom took a paradigm shift from monarchy in the favor of democracy. So that was just like a trader was coming in particular area of his kingdom, and then he used to offer some kind of gifts to the king. And then when the king would take the some gift by the trader who is coming from the other places, then he was allowing that person to enter their goods in their kingdom, or they were allowed to sell in the market, right? But later on it became the part of the law, as the custom act was passed in 1962 by replacing erstwhile sea customs act 1978. So earlier it was called as a sea customs act 1878, where because the majority part was done only by sea, because there were no export or import were happening due to the airways, roadways, or any other things. So majority thing was done by uh, the sea itself. So it was called as Sea Customs Act 1878. But later on, the act was modified. It was changed to Custom Act was passed in 1962. Further, Custom Tariff Act was passed in 1975 to replace Indian Tariff Act 1934. So there was one more act also, which was called as Indian Tariff Act, which was passed in 1934. But that also act has been replaced after independence. It is now called as Custom Tariff Act, right? And it is passed in 1975. At present, the Custom Act consolidated the provision as to levy and collection of duties on import and export of the goods. The current custom duty or act, it has said all the definitions, circumstances, how to levy the tax, what are the exemptions included, and how to do the collection of duties and duties of import on and export of the goods. So each and everything now it is contained, and it is specified in the Custom Act, right, in the Custom Act of India. So now about indirect tax. Custom duty is a form of indirect tax. It is levied by the central government on import of goods and export of goods from India through air, water, and land route. If any of the goods, if they are either imported to India or they are exported to some other country from India through any of the modes, it can be from airway, waterway, or by land also. So such kind of transportation has lead to a particular kind of duty has come into a picture, that is a custom duty, and it is an indirect form of taxation. Now, what are the sources of custom laws? As we see that there are various sources of each of the law of the government of India. Like India has taken the different law from the various places. Similarly, there are various sources of custom laws. So how the custom law is made? by taking the information, data, or the different kind of things required to make a law from the different sources. The first important source is Custom Act 1962. It extends to the whole of India and save as otherwise provided in this act. It applies also to any offense or contraventions thereunder committed or outside India by any person. Right now, this Custom Act 1962, this has been inserted by the Finance Act 2018. Like it has changed. It is now applicable to whole India, including Jammu and Kashmir. Okay, so the Custom Act 1962 is the first and foremost important source of any kind of legal or lawful data for the custom laws in India, right? If anything happens between importer and exporter, between while exporting or importing the goods, majority of the part in the court and in the while legal things will be taken from Custom Act 1962, and you have to follow all the rules and regulation which are said in Custom 1962. The second act is Custom Tariff Act 1975. Okay, this is also very important. It contains the provisions relating to various types of custom duties and classification of import and exempted goods. This act contains two schedules, right? Basically, tariff is classified the goods. Now, what is the tariff applicable? Like for all the goods, you cannot pay the same amount of tariff. So they have made under the Custom Tariff Act, they have made as Schedule 1 and Schedule 2. The first schedule gives the clarification and rates of duties for import of goods into India. It is called as import tariff, right? So there are rate of duties. So what kind of goods you are importing, and what is the rate of duty, and what will be the tariff you're going to pay, the final import tariff. Second schedule gives the clarification rate of the duties for export of goods. Right now, when you export the goods, now what are the different kinds of goods you are exporting? Now that goods will be classified, and then what are the export tariff you are going to pay? Right, is that is also applicable for it. So that is defined in Schedule 2. So this particular act which defines about your tariff, your rate of duties under import tariff and export tariff, that all things are said under Custom Tariff Act 1975. Okay, next is third act, rules under Custom Act 1975. So this as per section 156 of Custom Act 1962, it empowers the central government to make rules. Such rules may provide for matters relating to a manner of determining the value of import goods, export goods, duty, drawback, baggage, right? The rules so framed are consistent with the provision of Customs Act 1962. Now the government, suppose as these are the act, now they can't change it without the higher permission of the central government, even by the Supreme Court. But if the government want urgently to do certain changes, or it has empowered this rules under Custom 1975, empowered the government to do certain related matters, or it can make certain rules, newly rules it can change in these act. So for that, the government has provided a different kind of things that is called as rules under Custom Act 1975. So these are the rules, additional rules also. It can be due to import, export, drawback, baggage, etc. Well, these all things, what are the rules? Additionally, you have to follow it. Those are said under rules under Custom Act 1975. Okay. Now, regulations under Custom Act 1975. There are different regulations also need to be followed. These are said by CBIC, that is Central Board of Indirect Taxes and Customs. Right. Whatever are the regulations are said under this Custom Act 1975 by CBIC, that is Central Board of Indirect Tax and Customs, is empowered under Section 157 of Custom Act to make regulations to carry out the purpose of this act. These regulations are to be consistent with the provision of the act, as well as uh, are framed by the central government. Okay, these rules are framed by the central government, and these are framed by the custom house agency by licensing regulation, etc. So these are very important, where these rules also need to be followed. And government, if they want to make any rules or regulations, they have a separate set of a body, that is CBIC, Central Board of Indirect Taxes and Customs. So they will make all regulations, and those regulations and rules will be framed under rule under Custom Act 1975 as per section 156. Now circular. The CBIC can issue circular instruction or direction for the purpose of uniformity in the clarification of goods or with the respect of levy of the duty thereon. So once the CBIC has made any kind of rules, because as they are empowered to make rules as per section 175 of the Custom Act, once they will make any kind of rules, that rules they have a power to issue it as a circular to the different government of the different states, right? They can declare this because to follow the uniformity in the clarification of the goods. If this is not issued in form of a circular, so there cannot be an uniformity. Somebody is following their own method, traditional method, so there will not be uniformity. So they have to issue a circular even to the central government, state governments. So from there it will be distributed to all people. Then notification. The central government has the power to issue notification under different sections, like for prohibition of import or export of goods, notified goods, etc. So the government also issues a notification that these are the goods which are prohibited to import, which are prohibited to export. Under section 11, these are all things mentioned, and notified goods are defined in section 11 subsection B. So these are also need to be followed. Now, what is the impact of introduction of GST on custom? Now, as you know that GST has come, so when GST has introduced, what kind of impact you are finding on the custom? The following are the implication of GST introduction on import and exports. When GST has introduced, the tax regime has been affected, or it has some impact on it. So import as interstate supply. Now, as because of the introduction of GST, the import are treated as interstate supply. So what do you mean by interstate supply? Interstate supply are those when you supply the goods from one state to other state, right? Like if you supply the goods from Karnataka to Maharashtra or Karnataka to Andhra Pradesh. So when the goods are being supplied from one to other state, those are interstate supplies. Now this custom duty will be similarly treated under GST as interstate supply. It is not treated as intrastate supply. It is not within the supply. Some other state it is treated. And when it is treated as interstate supply, then IGST will be applicable under GST, right? Integrated goods and service tax is applicable. So this is the first effect. Second is import of services. Whenever the goods are imported, the integrated tax on such services would be levied under the IGST Act as per section 7 subsection 1 subsection B of CGST Act 2017 has also introduced the import of services for a consideration as the supply. Okay, if anybody even has imported any kind of services or any kind of goods, and all these supply of services or goods are considered as a supply, and these all things whenever are imported from other places, there it will be levied under IGST. Because first point we saw that we are treating the import of the goods, import of the supply as the interstate supply. Now when you are treating the import of the supply as interstate supply, so then IGST is directly going to be applicable. Neither CGST is applicable nor SGST is applicable. Directly on the import of services, the import of supply, the IGST is going to be applicable. Okay, then import of goods, the levy of IGST on import of goods would be levied under section 3 subsection 7 of Custom Act 1962, read with the Custom Tariff Act 1975. Not only services, but also if you are importing any kind of goods, there also IGST is applicable, but these are levied under section 3 subsection 7 of Custom Act. About services, it was levied as per CGST Act, like as per section 7 subsection 1, but now this is levied as under section 3 subsection 7 of Custom Act. Right. So, and also with the reference to Custom Tariff Act 1975. Then import of goods or services on the export side, export would be treated as zero rated supply under section 16 subsection 1 of IGST Act 2017. Now if you are exporting some goods, So you got a lot of relaxation. On some of the goods, it has treated as zero rated supply, where you don't have to pay any kind of GST on it, especially on the export of goods, right? So, and it is also governed by IGST Act of 2017. So what is the geographical jurisdiction of Custom Act 1962? So as Custom Act 1962 applies to whole India except the state of Jammu and Kashmir. Earlier, it was not applicable to Jammu and Kashmir. Now, this act, Custom Act 1962, this is also applicable to Jammu and Kashmir, right? As because of the various change in some article by the government, and it may be done, it has done with the effect from 29/3/2018. It is applies to offense or contravention thereunder committed outside India by any person in India, including territorial waters of India, or any kind of place in India, or all geographical places in India. This Custom Act 1962 is going to be applicable. Now let us see how the import and export routes will happen. The import and export routes are happening nowadays. In earlier time, it was only happening with the sea or a water route, right? Because there were no airways which were carrying the goods from one place to another place. Land route was also not that popular, right? Now the new and the latest, where the import and export happens by the three different kind of routes. There is sea, water route we call, air route we call, and land route we call. Okay, now import and export, as it happens with the waterway or water route, air route, and land route. In air route, in water route, the first is the mode of transportation. So what are the various mode of transportation? The first mode is vessel or ship. It transfers the goods from a vessel or a ship, which are one and the same. Then persons in charge. So who has transferred it, right? Or to whom the goods have been transferred in India. So that is, he is a person called as persons in charge. Now, master of vessel is a ship. So what will be the main master of vessel on which it will be treated as the import? That master of vessel is ship. Ship is main master of vessel. Under a ship, there are various vessels again, right? Under a vessels again, various containers. So the master of vessel is ship. Now, it is generally landed on, where it is landed on, it is landed on the custom port. In India, there are various custom ports, like Visakhapatnam is one of the most prominent oldest custom port, right, where all the goods will get landed, right? So similarly, the goods will get landed there, and from there you are going to decide at what particular things goods will move to one place. Whichever state you are want that goods, the goods will go to that place. So this is how the custom, we can call as the sea route, will happen. But when you say about air route, it has a different kind of route. In air route, first of all, the mode of transportation is aircraft, right? Aircraft. Then persons in charge will be responsible, right? One who is either, if you are exporting the goods, the person who is exporting the goods, he is the persons in charge. And if you are importing the goods, the person who is importing the goods is called as persons in charge. And then place of the aircraft, wherever, in whichever place you are bringing the goods, right? That place is called as the pilot of the craft, right? A persons in charge, and the pilot of the craft is called as the persons in charge in case, right? Because he is the person who will be driving who will be bringing your goods from other country, right? So he's a pilot of the aircraft. Then wherever it is landed on, that is custom airport. Now where it is landed, whether it is landed in Mumbai, Bangalore, Goa, where it is landed, that area or that particular thing is called as custom airport. And on that itself, you will be liable to pay your all custom duties. Then due to land route, mode of transportation generally will be vehicle, right? It can be bus, it can be any other way. So now the persons in charge, who will be persons in charge? A driver of the vehicle. One who is driving the vehicle, he will be the person in charge. Then where it is landed on, such land is a land of land situation, or particular land is a land of custom. Wherever you land a vehicle, whether it is Kashmir, Punjab, wherever you landed it, that land situation, it is the land of custom duty. Okay.